Hello and welcome to North Country Matters. My name is Donna Seymour. I'm a member of the St. Lawrence League of Women Voters, one of the civic partners for our show. Today, we're going to be talking with Corinne Carey, the New York and New Jersey campaign director for Compassionate Choices, an organization that advocates for legislation to permit terminally ill people to request medication to end their lives. Corinne, welcome back to North Country Matters. We had you on to talk about this legislation 2 years ago. I'm happy to have you back for an update on this important campaign and to see if we've actually moved forward in the last 2 years. So,
Yes, well, thank you so much for having me.
well, my pleasure. So let's give people a little bit of background on this bill. It is not new legislation by any means. 10 other states already have some form of this legislation in action. And in fact, the Oregon Death with Dignity Act has been in effect for more than 20 years. So tell us a little bit about the compassionatechoices.org and what it does and who it's for.
Sure, and thank you so much for that introduction. Actually, Oregon's experience with medical aid in dying is now more than 25 years old. So we've got a quarter of a century of experience in this country with the compassionate option of medical aid in dying. My organization, Compassionate Choices, is a national nonprofit organization dedicated to helping everyone chart their own end-of-life journey. So changing laws and policies across the country is an important part of our work, but it's not the only thing that we do. We help people do their advanced care planning to make sure that their wishes are respected at the end of life. We bring impact litigation cases to make sure that people who have made their wishes known, those wishes are respected by healthcare professionals. We do a lot of community education about the importance of end-of-life care planning and what people's options are. And we have a fantastic tool for helping people who are thinking about dementia and how to plan for the care that you want should you receive a dementia diagnosis. Those tools are available in English and Spanish online and in print form from our organization. So the scope of what we do is quite vast, and the organization has been around for more than 30 years. So yeah, just wanted to give your viewers a chance to understand a bit more about the organization.
Well, and every one of those things that you just talked about is so important for anyone who is perhaps received a terminal diagnosis, as you mentioned, perhaps facing dementia and wanting to make sure that their wishes are respected and will be taken into account. And that is so critical as people begin to think about their end-of-life choices. So let's talk specifically about what medical aid in dying is, Corinne. Let's define what it is and what it is not for folks.
Thank you. Yes. So medical aid in dying is would allow a terminally ill person who's been given a diagnosis of an illness that is both incurable and irreversible, and also a 6-month prognosis. So determination by 2 doctors that they are likely to live for only 6 months or less, so long as they are determined to be mentally capable of making healthcare decisions. It allows that kind of person to ask their doctor for a prescription for medication that they can take at a time of their choosing, or never, should their suffering become unbearable. Medical aid in dying laws in the United States all have the same core eligibility guidelines. One has to be an adult, 18 years of age or older, a terminal illness, mentally capable, 2 doctors needing to confirm, and the ability to self-ingest the medication. Each of the laws in the 11 jurisdictions in the United States that now allow it have more than a dozen safeguards attached to them. And I can talk to you about what some of those safeguards are, but suffice it to say for these introductory remarks that these safeguards have really resulted in ensuring that only those who are truly dying take advantage of these laws, and that from start to finish, it is only the dying person who is making the decision. No healthcare proxy, no guardian, no doctor, no family member can request this for the person or administer the medication to them. And then the last thing I think it's really important to understand from a 30,000 point view is that these laws are voluntary. No patient, no doctor, no pharmacist, no health system, no hospice needs to participate. This is truly voluntary, and there are protections for those who comply with all aspects of the law, and there are also protections for those who opt out.
So really what we're talking about here is in New York State is no different than what has been enacted in these other 11 states. We're not breaking some kind of new ground here, are we? We're simply following the precedent that's been in place in Oregon's case for 25 years.
That's right. And we follow that model as every other state has done because it works.
Mm-hmm.
There have been no problems with implementation. No one has faced criminal prosecution. There have been no disciplinary charges brought, and there have been no exposés of, something happening that the opponents are predicting might happen. So, for example, the same arguments that opponents have raised in other states, notably in New Jersey, our neighbor, which passed the law in 2019, none of the predictions for harm that those opponents raised prior to New Jersey's passage have come to pass in that state. What we've seen, and I'm on the ground dealing with families and the Department of Health and doctors in New Jersey, what we've seen there is that the option has provided an incredible peace of mind to people facing serious and terminal diagnoses in that state. And as I said, none of the problems predicted by opponents have ever come to pass.
Right. So there have been some additional safeguards to the current bill in New York State that is under consideration that were added this year. Can you tell us something about what those changes are and what they mean?
Sure. One of the concerns that we've heard from lawmakers is a distrust of health insurance companies. And we all know that our healthcare payment system is quite broken in this country, and that many people who need life-saving treatment are often denied coverage for that treatment, and they have to appeal the decisions. All of us who have health insurance have been in that situation. And I think lawmakers were concerned that health insurance companies would use the existence of a medical aid in dying law as yet one other excuse for denying coverage. One, we've not seen this happen in other states, but two, the existing law, the existing bill provided that protection. What the amendments this year did is make them absolutely explicit. We spelled it out. Our bill sponsors, when they amended the bill, spelled it out quite clearly that no insurance company can deny payment for something that they would have covered under their contractual obligations prior to the existence of a medical aid in dying law. So that protection in the bill, that safeguard, was shored up. The other change that was made this year is to make it absolutely explicit that those who opt out of providing medical aid in dying or responding to a patient's request for medical aid in dying are protected from civil and criminal immunity. So someone cannot be brought up on disciplinary charges, for example, or sued in civil court by a patient who wants to use medical aid in dying, but whose provider is unwilling to do so. So it shored up what some people refer to as the conscience protection in the bill, which was quite strong to begin with, but now is even more explicit with providing that immunity.
Those are two really good provisions. And you speak about insurance companies and the for-profit system always figuring out some way to get out of the kind of coverage that they claim that they give you. So I think that's really an important point, that people aren't going to be hurt by this if they make this decision in terms of having all of a sudden the coverage disappear. So what is propelling the legislation this year? What are the issues? You've got some new endorsements as well, don't you, in terms of groups that have signed on to this?
We do. Important new endorsements. So one of the most notable is that the Medical Society of the State of New York changed its position from opposing the bill to supporting it. And that's important for a number of reasons. We've recently heard from legislative leaders that this bill needs more education and more discussion. And what we know is that voters and organizations that represent the wide diversity of this state have been discussing, debating, investigating, researching, and educating themselves about medical aid in dying across the country. So these discussions have been happening in a robust way for 10 years. Perhaps the leaders are, otherwise occupied, and we know that there are a number of very weighty issues before them. So, in some ways, I can understand if they feel like they've not engaged in that education and discussion, but everyone else has. And so, for us, we feel like the medical society joining us, the ALS Society of Greater New York joining us, the New York Association of Counties recently coming on board last week. This is all evidence that the time is now to have a public debate on the floor of the Assembly, on the floor of the Senate on this issue, because everyone else has been having these discussions, and now it's up to the legislature to have it for their constituents. Either way, lawmakers need to hear from their colleagues in a public way about how they feel about this bill, and their constituents need to hear it. These discussions have to move from behind closed doors in Albany to the floor so that all of us can see where lawmakers stand on this very important issue of patient autonomy.
And that's particularly important at this time this year because there aren't that many days left in this legislative session, and then the legislators are all going to be going home and asking for your vote. So for the most part, we need to know how they feel about the issues that we have sent them there to deal with. So the timing on this is important. And I remember from our conversation 2 years ago that you did a statewide trip around the state to talk about these issues region by region to also bring the public into these discussions.
We did. It was, look, from the beginning of this campaign in 2015, I've traveled the state from Buffalo to Brooklyn, where I hail from the North Country all the way to the tip of Long Island. And we've been holding community discussions that entire time. Our winter tour, which, as you mentioned, was 2 years ago, brought us to every region of the state where we invited lawmakers and community groups and the press to engage in a number of activities with us to learn more about this bill. And we've answered all of the questions that have come up. We've presented the evidence. Yesterday, we did a speak out in Albany where we read from more than 250 pieces of materials that we've shared with lawmakers over the past 9.5 years. We read as much as we could get through aloud for 8 hours in front of the chamber because, again, for any lawmaker who says that we need more discussion or there's not been enough education, they need to understand that we all, the voters in New York, have been doing this, and we need them to catch up.
And that's really a key of this whole movement, isn't it? That the people are behind this legislation. You've done your outreach, you've done your education, there's an awareness of the problem, and there's a consensus about what action should be taken. So really, you're in a good position in terms of asking the legislator to move because the people already have, haven't they?
Without a doubt. I mean, poll after poll shows that a vast majority of New Yorkers across every demographic, Democrat, Republican, Independent, different religions, different races, supports this notion that people at the end of their life should have options, and particularly options that our neighbors in Vermont, New Jersey, Maine, and other states now have. We have more than 52 statewide organizations that have come out in support of this bill, some after years of deliberation. And there are 86 bill sponsors. So lawmakers themselves have been coming on board as they see the endorsements pile up. It really is just a matter of the leadership saying, this is not a controversial issue. The numbers tell a different story, and we need to bring this forward for a vote.
And one of the things I think that we should talk about, Corinne, is what are the options that people have now at the end of life? Those options don't go far enough, and they certainly do not relieve the suffering of the terminally ill patient, do they?
Not in all cases. There are some, what doctors are now calling death profiles that are particularly difficult to meet with the existing options that we have. Of course, every person who's diagnosed with a serious or terminal illness has the right to pursue all the treatment options that are medically available to them, limited only by their ability to pay. And that is a big caveat. But we all have the right to pursue that treatment. Conversely, the United States Supreme Court has affirmed the right of all of us to stop or decline treatment. So at any point during that process, we can say enough is enough and I no longer want to receive this treatment. Once that happens, there are a number of options that kick in for people. If you have a terminal diagnosis, you can avail yourself of hospice. Here in New York, you can do that if you have a 1-year prognosis in most cases. Federal benefits cover those who have a 6-month prognosis. So, once you're at that stage, you can avail yourself of hospice, which is a set of services delivered to people in wherever they call home and supports people in realizing their end-of-life goals. It's not curative treatment, but hospice is a set of wraparound services that help support people in maximizing the quality of their lives. If traditional pain medication is not sufficing to relieve someone's suffering, folks always have the option of specialized palliative care that is delivered in quality hospitals across the state. And they have the option to perhaps, if that's not sufficient, stop eating and drinking. This process is called VSED, or voluntarily stopping eating and drinking, and should be done with the help of a medical professional and support of a family. It's not an easy process, and it's not always peaceful for people. It has provided peace in hastening death to some, but for others it has caused agitation and has been quite a painful process, both for the patient and their family. If voluntarily stopping eating and drinking is not an option or is not sufficient, folks also have the ability to access what is called palliative sedation. And in layman's terms, it's known as putting someone in a medical coma and withholding nutrition and hydration as that person dies. And so it reduces consciousness. The problem with palliative sedation, of course, is that if you provide too much sedation, you bring about death, which is not permitted. And if you provide too little, then someone can regain consciousness. And that is very disturbing, both for them and for the people around them as they rush to try to calibrate the medication to put them back in the coma. So it's not a perfect solution, and that's why medical aid in dying is a tool that many hospice and palliative doctors are now saying they need in their toolbox for patients to have some measure of control at the end, should these other options not be sufficient.
Yeah, and as all medical people know, that is not how you want things to go, but sometimes if it's going to happen anyway, you don't want additional suffering and you want it to be as peaceful as possible, and that is always the ideal. So Corinne, we're close to the end of the legislative session. Why hasn't this bill moved onto the floor yet?
We've got 12 days left, to be exact, which in some ways is a very quick timeline, and in other ways, if you're in Albany, in the political experience, in the political realm, it's a world of time, and there is enough time if the leaders have the will to do it, to move it. Why isn't it moving? I would say that there are two big barriers right now. One is that lawmakers tell us it's an election year and it's hard to do something controversial in an election year. And our response is, how can someone that enjoys the support of more than 72% of voters, both doctors and lawyers agree, which is, a rarity, and has so many other groups endorsing the measure, how can this be deemed controversial? And the fact is, there are some really passionate lawmakers who are very opposed to this issue, and opponents who are passionate about their opposition speak the loudest. And so, it becomes difficult to move a bill that so many good lawmakers feel so uncomfortable with. But what we try to say is that, this is the perfect issue for an election year. How often is it that you get to please such a large portion of voters with something that's all about love and compassion? This is an opportunity for lawmakers to demonstrate that love, compassion, and respect for their constituents, even if they themselves feel uncomfortable about this by bringing this bill to the floor. So this is a winning issue for elections, not an issue that would jeopardize anyone. No one across the country has ever lost their seat because they have championed, sponsored, or voted for a Medical Aid in Dying Act. One of the other arguments that we hear is that this is not on anyone's top 10 or top 30 list. And, if I weren't leading this campaign, to be honest with you, it might not be on my top 10 or top 30 list either. There are so many important issues, from environmental issues to criminal justice, racial justice. I get it. This issue isn't a priority for anyone until it is, until you or a loved one are facing down a terminal illness. But that argument that this isn't a priority for anyone also means that it's not going to be an issue that people vote you out of office on. This is not the most important thing to the voters, even though the majority of voters want it. So I hope I've explained that, because it is a little bit tricky to understand how that argument can play in both different ways. But it's a winner. It doesn't jeopardize anyone. And it's a real opportunity to lead with love and compassion.
And when you need this legislation, when you need this act for yourself, it is not something that you can go out and order up in a quick way. It's got to be done well and ahead of time, exactly as you are doing. You've worked on this for 10 years. But when it gets into place, when someone needs it, it's there. And as long as it's not there, they still are going to need it when the time comes. So it makes a lot of sense that this is a great time to do that, and then it's taken care of. So let's talk a little bit about what the next steps for the campaign are. What happens if the bill passes? What happens if the bill doesn't pass? How do we go forward from this point?
So it's hard to think of a world in which this bill does not pass by June 6th, but we do have to consider that. So I'll start there and say that if lawmakers refuse to pick up and pass this bill, I think that there are going to be some very angry voters out there, and I wouldn't be surprised if we see them raising their voices prior to the election. So I think that that's what we'll see from corners around the state, with groups that have been heavily invested in passing this bill. So what it means logistically is that the bill dies and needs to be reintroduced all over again, and sponsors need to add their names, and we may see a pretty large turnover of elected officials. So there's going to have to be some swift education prior to January, when the bill will be reintroduced, and then we'll push for passage in a non-election year, because that excuse will be out of the way early in the session in 2025. I really hope and pray that that does not happen, because 6 months is a very long time, and anything could happen to any one of us in those 6 months. And right now we're working with 6 terminally ill advocates who are raising their voices on this issue. And we may lose one, more, all of them between now and January. And we've already lost 26 advocates, many of whom died with a tremendous amount of suffering. And so that will be on the legislative leaders' hands if that should happen and they don't bring the bill up before June 6th. So that's the scenario if the bill doesn't pass. If the bill does pass, I am very proud of the relationships that we've forged with a number of health systems and medical groups representing medical professionals. I know that they have already begun educating healthcare professionals about how to respond to requests for medical aid in dying. And so I feel confident that when this law goes into effect, that there will be immediate relief for people living with terminal illness. I know for sure, based on my experience in New Jersey, that the simple existence of this law will provide a tremendous sense of peace to those who need this option. And I feel confident that there will be a number of doctors ready, willing, and able to respond to those requests immediately.
And of course, it's also true that just because someone has this in their repertoire, it doesn't mean they choose it. Sometimes, oftentimes people want this protection, but they don't actually end up using it, do they?
They don't. And that's a really good point. A number of our terminally ill supporters describe it as an insurance policy. And really what we've seen in the 11 jurisdictions that have adopted these laws is a funnel effect. A large number of people gain the benefit of knowing that this is an option, and they have conversations with their doctors about what they fear most about the end of life. And they're then referred to appropriate services. It helps with, people getting into hospice sooner and in a more appropriate fashion. Then many fewer people actually make a formal request for medical aid in dying. Even fewer qualify. Even fewer make it through the entire process. Even fewer get the prescription. And then what we know is that between a quarter and a third of those who are approved for the prescription either never pick it up or never use the medication. It simply provides that peace of mind, knowing that should suffering become too great, there's a door that they can open and exit.
Right. And of course, in New York State, the bills have to get to the floor, which is the responsibility of the leadership in both houses. Then they have to get passed, and the governor has to sign them. So there are still some steps that have to be taken. What can people do to help at this point in the process? What can citizens do who care about this issue?
Well, they can make 4 phone calls today. One is to Senate Majority Leader Andrea Stewart-Cousins, telling her that, time is up. We've done the discussions. We need to move this bill to the floor. Pass or fail. Constituents, voters need to know where their lawmakers stand. The second call, echoing that, is to Assembly Speaker Carl Hastie, saying the same thing. And then folks need to talk to their own senator and their own assembly representative and make sure, no matter what their position is on this bill, even if they're a bill sponsor, they need to know, every lawmaker needs to know that their constituents stand behind this bill.
Okay, so as we wrap up today, Corinne, do you have any final thoughts you want to leave our viewers with about this issue, this campaign, and what the future holds?
Well, the first is logistical. We need as many voices as possible in this campaign. And so I would encourage folks who want to see this law pass, reach out to us. You can find us on Facebook, Compassionate Choices New York. You can find us on Instagram, LinkedIn, Twitter, X, and you can visit our website, compassionatechoices.org/New York. You can email us, ny@compassionatechoices.org, all one word. We need bodies in the Capitol. So if you're willing to travel to Albany over the next few weeks, we need you, particularly next Tuesday, May 21st. And we need your voices on the phone to these leaders. I think what I would leave your listeners with is that this bill will pass. Of that, I am confident. It's just a matter of how much more suffering our legislative leaders are willing to tolerate. And finally, when this bill passes, nothing changes for people who don't believe that medical aid in dying is the right course of action for them and their families. Nothing changes. This is an option for people who want it, and it will provide a tremendous sense of peace to all of us who believe that we should have autonomy over our bodies at every stage of our lives.
Thank you, Corinne. These are never easy discussions to have. This is not a topic that rolls out of every conversation when people get together. But anybody who has ever faced an end of life situation for a family member or a friend has had to think about it. And so the fact that you're doing the work you're doing and that so many passionate advocates are doing this work is important, because, as you say, at some point we will get over the finish line with this, and that people will have this choice, never have to take advantage of it, but it'll be there for them. So thank you so much for coming in today and talking about this with us.
Thank you for having me, and thanks for engaging in this conversation.
Well, I want to say to our viewers that this show is dedicated to the memory of one of our local League of Women Voters members, Eileen Raymond. Eileen died last year, but Eileen was a passionate advocate for many issues, this one in particular. And this is one of the last issues that she worked towards as an advocate, was the passage of the Medical Aid in Dying Act here in New York State. Like many other people who were faced with a terminal illness, she wanted to protect her choices. And unfortunately, she did not live long enough to see this bill pass, but we want to dedicate this show to her memory because of all the work she did on so many social justice issues in her life. So these conversations are a production of North Country Matters. This show is a civic collaboration between the League of Women Voters of St. Lawrence County and the Potsdam Public Library. Until next time, remember, our North Country matters.